Welcome to Byrna's Hot Take, where we discuss self-defense topics, tactics, and training so that if the time comes, you are prepared to defend. On today's episode, I have a very special guest for you. Former prosecutor and criminal district attorney Rebecca Millo has joined us today to lend her expertise to Byrna Nation so that we can discuss some of the finer points of the legal aspects behind the use of force, self-defense, and kind of the application of that force, and really take a deeper look at some of the incidents that we've been seeing around the country where, kind of self-defense has gone not necessarily the way that we thought it would, and really talk to Rebecca about how we can mitigate some of that liability and make sure that, if we're going to use self-defense, if we're going to use force to defend ourselves, defend someone else, that we're doing it in a manner that makes sure that legally we're as safe as we can be. So thank you so much for joining us today. Really, really excited to have you on.
Thank you for having me.
Yeah, absolutely. So just real quick, kind of introduce yourself to Byrna Nation. Give us a little bit of your background, how you got to where you are here and doing the
Sure.
criminal work.
So I started in the Galveston DA's office in 2004, and I worked there for 18 years. I always tell people I've tried almost 100 cases, and I've tried everything from a Class C untagged redfish up to a capital murder, and that is a thing. And people show up, and they will testify. So I've tried everything you can think of. And I left the DA's office in March of 2022 and started my own law firm doing criminal defense, and I've been doing that for just over a year. And it's a whole new world, but I'm enjoying it.
No, that's fantastic. Do you feel like, obviously, I'm sure that your experience as a prosecutor has really kind of helped, on the defense side. Are you seeing some of the same issues kind of on both sides that you saw, in your experience as a prosecutor, and some of the issues that, that we see throughout the country and especially locally here? How are you seeing stuff trending now that you're on the other side when it comes to, some of the use of force cases you're seeing and getting?
Absolutely. I think one of the things I always tell my clients now is how I can tell you what the prosecutor is going to see when they read a case, because I did it for so long, for 18 years, is a really long time. And it's almost like I've had to retrain my brain to think in a different way. But at the same time, thinking as a prosecutor is a very good way to approach a defense case, So it's helped me to be able to evaluate a case, look at it, and think, okay, if I were still a prosecutor, this is how I would argue this, and I think that is able to lend me the ability to attack it from the defense side. And then self-defense, use of force, all those types of things are still very prevalent in our cases that we get on this side as well, and they just present a little bit differently as a defense attorney.
I can imagine. So, we talked a little bit before, and you brought up some really good points about self-defense. And obviously, we talk about self-defense a lot. We're a self-defense company. This podcast is primarily about self-defense, but you brought up some really interesting points about the term self-defense and about what it really means to defend yourself and, defend yourself practically in a situation, but then also legally. When we utilize the self-defense, kind of claim in a case where we have used force against somebody else. So you share with us some of those, kind of that insight on what self-defense really is.
Sure. So Texas, is a stand your ground state, and I think everyone knows that term, and they know self-defense, or they think they know self-defense. But I think the part that gets lost a lot is that it's what the actor is doing. Are their actions reasonable? And I think that's the big keyword and kind of the big takeaway is a jury is going to determine if your actions are reasonable. And I think one of the things we were talking about is a lot of people like to say, I was acting in self-defense, and that phrase gets thrown out a lot, but people do not necessarily know that there's going to be a bigger determination of those actions.
So what is that determination of when we're talking about self-defense?
If you are engaged in some type of behavior and you get charged and you go to trial, and you raise the issue of self-defense, it then becomes the burden of the state to prove beyond a reasonable doubt that your actions were not reasonable, that self-defense does not apply to you. So the state is going to have to basically disprove self-defense, which sometimes gets pretty hard for a prosecutor to do.
That sounds like a very strong initial stance to take for a defendant, saying, well, I was acting in self-defense, and now the prosecutor, the state, the government is having to prove that it's not self-defense.
Right.
Yeah, sounds very strong.
It does, and it is, and I think it is. I feel it is. Sure. But there's a whole lot of factors that go into saying, well, I was using self-defense. Well, were you? Because they're going to really nitpick all of your actions. Like, we're going to look at everything before, during, and after an event, right? Crimes don't happen in a vacuum. There's so much more that goes into it. What were you saying? What were you doing? Did you call anyone afterwards? Did you text anyone afterwards? Were you upset when the police showed up? Like, what is your demeanor? So there's a whole lot of factors that are going to come into play as far as, is this really self-defense? And everything you do and everything you say is part of those factors.
So, when we talk about, and not to really get too deep into it, because we could get pretty deep into the weeds here. But, But when we talk about the different regions of the country, because obviously things get prosecuted very, very differently.
Correct.
Depending on what part of the country you're in. And I think that's, and correct me if I'm wrong, I think that's a lot of that is driven by the Circuit of Appeals Court that you're in, what region,
yes.
that kind of rules over you. So, Texas being in a court of appeals that really measures more of a moment in time versus, say California that's in a circuit court that's totality of circumstances. How much is that going to? I mean, are they still really diving into, all the factors that kind of went into that self-defense claim?
So, I think they do to an extent. Because again, like I said, you don't try a case in a vacuum, and these events, and they do happen spur of the moment a lot of times, right? But your actions are definitely going to be evaluated to a very minute degree. What were you doing? What did you say? What did you do immediately afterwards? Did you call 911? Did someone else call 911? And when the police showed up, what did you do? Did you talk to them? Did you tell them what you were doing? Were you upset? Were you crying? So a lot, it is, I think Texas not saying, well, it's a totality, but it kind of is. Yeah.
That's very interesting and very good to know that even in a quote unquote moment in time court, that there's still, they're still looking, and I'm sure you've experienced that in some of the cases where, moment in time may have looked one way, that you start bringing in, like you said, everything you did before, during, and after, and then it completely changes, what it actually looks like. So
correct.
That's obviously a very good piece of information to understand when we're talking about self-defense.
So, and I will say, as a prosecutor, when you're trying those types of cases, when you're raising the issue, when you think self-defense is going to be an issue, and you are in jury selection and you're getting ready to try this case to a jury, those are things you're definitely going to talk about to your jury panel and getting your 12 in that box. You're going to talk about how these cases happen very quickly, but you're also going to talk about before, during, and after. And all of that's going to come into play as far as trying to get that jury. So you talk about it from the very beginning.
Oh yeah. So understanding this and understanding now that what we're talking about and looking at all those factors in self-defense, there's a couple recent cases that I want to take a look at and really kind of pick through them to see why we're seeing some of the charges brought and rewinding that a little bit and talking about maybe some of the other options or maybe some of the things that they could have done to help mitigate their exposure to that legal liability. So the first was just last fall, was a shooting up in Dallas at a Family Dollar. You may not have heard about it. If not, check in the comments below. I'll absolutely link the article video to it. But just to give you guys a kind of a synopsis, there was a shoplifter inside of a Family Dollar. He was attempting to steal some items. Two of the female employees tried to stop him. He started fighting, struggling and fighting with them, ended up hitting one of them, I believe. One of them sprayed him with pepper spray to try to get him to stop fighting. And then a customer came in. A customer saw the scuffle, came in, and ended up shooting the shoplifter. And of course, he ended up dying as a result of his injuries. So a couple days of investigation go by. They end up charging the shooter with murder in that particular case. So, and obviously the discussion has been kind of heated going both ways. But, looking at that case, what are some of the things that stand out to you? What your prosecutor and your attorney, kind of brain, like some of those red flags that go up to you as to, well, this may be why they would have charged him.
I think the biggest thing is he was leaving the scene. He was
That's right.
He was on his way out the door, and he was shot in the back. And so that is hard to make an argument for self-defense. Hey, I'm in fear of my life or someone else's life.
Because at that point, he was no longer presenting.
Correct. He's retreating. And, Texas doesn't have, we don't have duty to retreat or anything like that. But he was leaving. And, the argument could be, well, we don't know where he was going. We don't know if he had someone else outside, if he had a car or a gun or whatever. So I would assume that may be coming up at some point. But that, to me, is kind of the biggest thing because he was leaving and then shot in the back. Obviously, there was this fight inside the store, and this customer walked in on it and was there to assist, and now he's been charged with murder.
Right. So understanding that, and of course, if he hadn't been leaving, that might have been one thing, or if he was still fighting, that might have been another. Rewinding and looking at that customer coming into the store, what would have been a more reasonable course of action in your mind? Would any level of force been unreasonable, or would a lesser amount of force probably been reasonable?
Right. I think some sort of lesser amount of force probably would have definitely been reasonable. I wouldn't see any issue with him trying to, detain him there at the scene, whether that was, him holding him. I've seen cases where people have been sat on and waited for the police. So that to me is reasonable. And
at this point, he's possibly committed attempted theft, and there's no criminal attempt, but theft or shoplifting, assault, thereby, possibly even felony robbery.
Right.
At that point. So he has committed possibly a felony at
Correct.
that point. So detaining him, all of that would be would be reasonable.
Right. I think so too. I don't see any issue with him having stopped him physically or put his hands on him. That to me doesn't seem, or
the use of the pepper spray, reasonable or unreasonable?
I think it's reasonable.
Okay. I would absolutely agree. Obviously, at that point, he's assaulting.
Sure.
Once again, we have the presence of a felony, even though they're not probably putting that together at the time.
Right.
But they're trying to stop the assault.
I am curious, and I don't know that I've read anything that kind of answers this question, but I am curious as far as the customer, where he was carrying his weapon and some of those types of questions. But I don't think anyone's answered that as far as, was it prominently displayed,
the open carrying or concealed carrying,
right, like
so that he would have seen that to cause him to run.
Yes.
Or I see, interesting.
Yeah.
So thereby a use of force in itself, just by the presence of
a weapon,
of introducing a weapon into that. That's interesting.
Right.
That could.
And there are no answers to that I have seen.
Not until this gets tried, which will, I'm sure, be not anytime soon.
No.
So,
no. Everyone's backlogged. Yeah.
That's the way it works. So definitely can see the whys as to why he was charged. Now, obviously, his conviction is going to be dependent on the jury and what they decide. But I definitely understand the charge and why it was placed on him. And I think a lot of people can also understand that was a fairly barring any other extenuating circumstances that may exist that we just don't know about, because that can absolutely happen. And what we hear about what gets released, especially prior to the case, is very, very limited.
Yes.
Because of that. So barring any extenuating circumstances, I do feel that was an unreasonable amount of force, and that a lesser amount of force would have absolutely.
I think a lesser amount of force, we wouldn't be here.
I
mean, if he had stopped him physically somehow, or even gotten physical with him, like in some sort of fist fight or something like that.
That would have been reasonable.
Right.
So let's jump over to another case that's kind of in the news. It actually happened around pretty much right around the same time, and that was up in Chicago. An off-duty officer, and the fact they're a police officer at the time really doesn't. I mean, and we'll kind of touch on it, if it bears weight or not. But off-duty police officer in Chicago goes to break up a fight in front of her apartment building, an argument, something going on, and then ends up in a struggle with one of those parties, who ends up, according to her and according to the video that's out there, is looking like he's struggling with her, possibly trying to take her gun from her. Then she shoots him. He ends up dying as a result of his injuries. And here we go again. She's now charged with murder. Once again, if you're not too familiar with the case, and if you want to become more familiar, link is below. There is very graphic video of this one. There was surveillance video that captures the whole thing. So it really lays out, what we're talking about. But, understanding this case, and there's some similarities to the Family Dollar case, but then there's some very big differences. What are, once again, those key red flags that go up as a prosecutor, as an attorney? What are those red flags that you saw in this particular case?
So what I found interesting about this case was the number of times that he was shot. She shoots him a total of 3 times, but after the first shot, he's pretty much stops what he's doing, and he's making some statements, and she then continues to engage with him, and she ends up shooting him a total of 3 times.
He's making statements that allude to him trying to not necessarily surrender, but be a little bit more compliant or stop the action that he's currently doing.
Correct.
But that's, looking at the video, not necessarily sure that that's exactly what he was doing. There's still some struggling.
There is still some struggling. There's some statements about how he was attempting to take her gun, or we don't know if he had other intentions to remove her from that location, to do something else, to assault her, kidnap her, something along those lines.
Because that's a lot of, because it's one thing when we go back to the Family Dollar case and we have, a clear case of most likely he has committed a felony robbery. He has committed a felony. He's in the commission of a felony, and that's why we're trying to stop that action. In this particular case,
we don't know.
We have, at best, at the moment, we have, what in Texas what we'd call Class C assault, which is assault by contact, because he's not necessarily causing her a whole lot of harm, but he's making unwanted contact.
Right.
Now, is he reaching for a gun? I guess that's something that they're going to have to
That's going to be
prove
fought
later.
out.
Yeah, exactly. But when we look at it on its surface, like you said, we don't know. You don't know.
He definitely, it's like he has her in a bear hug.
Mm-hmm.
Like you said, that could be Class C assault. He could be reaching for her gun. He could have had the intent to do something else, and we don't know what that intent was. But again, kind of like we were talking about earlier with the before, during, and after, she had gone down there and I guess broke up a fight or something. I would like to know what his involvement in the earlier altercation was.
Interesting.
But also, we don't, if he was really active in this earlier altercation, she's still standing there with him after everyone else has left the scene.
Right.
So there's a lot of things there that I guess haven't really been answered. And again, we won't know until it goes to trial, which will be in 2 years, maybe.
Plus.
But there are some things, and in addition to all of that, she makes some statements to him.
Let's talk about that, because I think that's going to end up playing a very large role in what gets brought to
Absolutely.
the jury. So what did she say?
She tells him, "I will kill you." And as a prosecutor, I would be jumping up and down, telling the jury every chance I got, she said she was going to kill him. As a defense attorney, I think my goal would be to try like hell to keep that statement from coming in.
Because that's pretty damning.
Yeah, I think so. Because no one wants to kill anybody.
It's never anybody's goal. I just want to stop the threat. I want to stop the act of aggression.
Right.
So,
Right.
But she seems to openly say, "I'm going to kill you." Not if you stop,
Right.
if you stop, I have to shoot you, or something to that manner, like stop,
Yeah.
or I'll have to shoot you. But she's making a statement,
Right.
And regardless of whatever her intention behind that was, probably, and in all honesty, it was probably just to get him to stop.
Right. Right.
But that's not what that's not what's going to be perceived.
And it could be, that she was so frightened that the response is, I'm going to kill you, because she's that scared.
And then I think she follows that up with, watch this, right before she shoots him.
Yeah.
And I think that that's going to be a struggle for the defense side.
It's going to be really hard to overcome those statements. And again, it goes into her frame of mind. What was reasonable? Did she act reasonably? Did she reasonably believe that she was in fear for her life? And I think you can make an argument she was reasonably in fear. And I think the first shot definitely disarms him, stops the struggle. Then you have 2 more after that.
Exactly. If you go back and watch one of our previous episodes where we talk about the physiology of a critical incident and low brain taking over, and we talk a little bit about time to start, time to stop, and basically your brain's ability to react to, hey, I need to stop, and then your body's ability to do that. But these were 3 pretty spaced out shots.
Yes.
This wasn't bang, bang, bang. This
Right.
was bang, bang, bang.
And that's another key aspect to it.
This seems like it was 3 decisions. It wasn't one decision to pull the trigger and 3 that just followed.
Right.
It was 3 decisions to pull a trigger, you're absolutely right. Looking at that, that's probably going to be a key role.
Yeah, that's going to be a very interesting case to follow to see the outcome. But of course, that's not here in Texas. So I don't know, as far as the difference between our laws and theirs,
Sure.
and how that's going to play out.
And we try to be very generalistic, but still, that same reasonableness standard is going to be the overarching
Right.
premise behind that prosecution. Was what she did, reasonable to 12 people.
Right.
So I'm very interested to see how that's going to pan out. Now, one other part about that, even though she was off duty, the fact that she was a police officer, what do you think? How is that going to play a role in?
I think police are held to a different standard. And I think and she will, claim self-defense. So as far as claiming self-defense goes, if you're in trial and you're going to make the allegation that this is self-defense, or you're going to raise that issue, if you're been charged with a crime and you're going to raise that issue, it doesn't take a whole lot, especially here in Texas, to make that claim. You can do it through cross-examination. You can do it through other witnesses. And I think for a long time we held on to the belief that if you are charged with a crime and you want to raise the issue of self-defense, that you then have to testify and raise that issue. And I don't think that that's really the case anymore. I've seen lots of cases where it comes in through other testimony, and can even come in through the defense cross-examining the state's witnesses and asking a lead detective, is there anything that could prove that this was self-defense or something along those lines.
Could this have been self-defense?
Correct. And that very vague hypothetical can get you there. I wouldn't say she necessarily would have to testify. However, if she did, as a prosecutor, they're going to talk all about her training and her experience, how long she's been on the force, and talk to me about, what type of training you've had as far as self-defense goes, and, proficiency with a firearm and things of that nature. So they're going to hit her pretty hard if she does, in fact, testify. And I do think that officers are held to a different standard because they are supposed to have all that training
Absolutely.
And experience.
As they should be.
Yeah.
So,
and so it'll be interesting. And I don't know that what I read said anything about like how long she had been on the force. Obviously,
I haven't seen that either.
If you have an officer who's been an officer for decades or, a few years, I think that can make a difference. I think she will definitely be held to a higher standard.
Interesting. So looking at both of these cases that we looked at today, both, it looks, I think one's a little bit more clear cut than the other,
Sure.
obviously. But, both, it seems that the arrests were made, the charges were filed because on the surface, what we're looking at, the force that was used was excessive. It was not reasonable for the circumstances that presented themselves. So understanding that, I think that some of the takeaways that we get from that are, it seems more and more, that, in this particular time period, and as we go on, it seems that more and more there is an expectation that you're, as a citizen, as an untrained citizen, that you have to look at a situation and use a reasonable amount of force.
Absolutely.
That the days of just, hey, they were breaking into my car and I shot them, oh, that's okay. That's gone.
Right. And I think, so I was thinking about this yesterday when I was thinking about what we were going to do here today. I think one of the things that's majorly different now moving forward is surveillance video and video in general,
yeah.
because it's everywhere. You have video surveillance in parking lots, apartment buildings, Family Dollar, homes. I mean, so many people have surveillance at home.
Ring cameras outside.
Yes.
Yep.
Even when I was still in the DA's office as a prosecutor, we started executing search warrants to get ring footage. Because people would, oh, well, this is what happened. And you can get that footage. And I think that has come into play a lot. Self-defense used to be a he said, she said, or he said,
Sure.
whatever. Whereas now you've got video surveillance footage that you can dissect and a jury of 12 people can dissect.
You're absolutely right. Just looking at these two instances, some of the biggest red flags that you brought up, like Family Dollar, the fact that he was leaving, that may not have come up without surveillance footage.
Right.
That it may have just been, hey, they were fighting. He comes in, they were fighting, he shot him, which makes it a very different story.
Sure.
Than he was leaving, and video showing that. And then, in Chicago, the same deal. When we see this, when we hear what she's saying, we see the space in those shots.
Right.
That's, rather than we got into a fight, he was trying to steal my gun, I was defending myself.
Had this been, I don't know, a decade ago, there may not have been video footage of her saying, I'm going to kill you, right? It could have been a very different case without video surveillance. And I think that changes the whole arena.
You're absolutely right.
So,
that is a huge, that's a huge aspect to both of these.
Yes. And not only video surveillance, but I always think of like kids put everything. They record everything. Yeah. And I say kids, but people younger than me. They record everything, right? Even as a prosecutor and now as a defense attorney, I have clients who record themselves committing crimes. And so video is everywhere, and I think that changes the whole landscape. When I first became an attorney, when I was first in the DA's office, we didn't necessarily have that. And we had cases where it was just one person's statement against another person's statement. And now you get presented with video footage, and everyone gets to dissect it.
Yep.
And when I say dissect it, I mean we dissect it. And people slow it down and blow it up, and it changes the whole landscape.
So it really puts the onus of responsibility on that person to make sure that they are using a reasonable amount of, if they're going to interject, if they're going to use that force, that it is reasonable. Because like you said, everything that video captures is going to be dissected second by second, tenth of second by tenth of second in court long after it happened.
Right.
And while, things happen very quickly in the moment, it's a dynamic environment and we can only process so quickly. Unfortunately, that's just not going to be how it's going to be looked at in a court of law by 12 people who are going to sit there and just absolutely dissect the minutia. Yeah. So I think that's a big proponent of having as many options, or having, good force options available to make sure that you can look at a situation and say, look, this is the appropriate and reasonable amount of force that I need to use, rather than just, going all the way, all the way to the max level. Saying, hey, look, this is the only force option I have, or this is just, I got to get it done. Like, look, man, that's just not right. We can't operate under that premise anymore.
Right. And the other thing I think is just being charged with a crime. I mean, it's a lot, right? If you've never been in trouble in your life and now you are charged with aggravated assault, murder, something extremely serious, there's different levels, right? Being charged in Texas is probable cause, which is a very low burden. Did this person probably do it? Whereas you taking a case to trial, you're talking about beyond a reasonable doubt, which is a very high burden for a reason, because we're trying to take your liberty, right? Yes, people have been charged, but we need to continue to watch and see how these things play out.
I can't agree with you more, and that's such a great point to bring out, that what we're looking at is a very, very small portion of what actually happened.
Right.
And making judgment now is very premature, and making sure that we look at the totality of the circumstances and everything that happened is extraordinarily important. But, I can also, just being charged with that crime, regardless of what happens down the road, I mean, that's life altering.
Oh yeah, absolutely.
And I hear it all the time. I'd rather be judged by 12 than carried by 6. And I get that, but I think that, and being on the side that I was on for a long time, and then you, and now having these clients, like, just that being judged by 12 part is life altering.
It is, it's frightening. And this is what I tell people all the time. I tell my clients all the time. I can tell you, based on my experience, what I think might happen. I cannot guarantee you anything. Never. I've seen juries do things I never thought they would do. I've won cases I didn't think I would win. I've lost cases I thought I would win. That's the nature of the beast. You don't know. You get a very short period of time to talk to these potential jurors before they're sitting in that box and they're making their judgment. You don't know. And the thought of it is very frightening.
Going into that and going into a situation where I could end up, being charged, not taking that very lightly. It
right.
is I think a takeaway from here, and understanding the burden that there is with having to utilize force in a situation like that, and understanding that, like you said, 2 years from now, you really don't know how that's going to,
right. How it's going to navigate through the system. You don't know. No one can tell you for sure with anything.
Yeah, absolutely. I think we've both seen that,
especially
you through our careers. So,
yeah.
Rebecca, thank you so much for
thank
joining
you for
us today.
having me.
This was incredibly insightful for me. I hope that it was incredibly insightful for you. Guys, if you like what we're doing here, I'd love to do some more case reviews and really break some stuff down for you. If that's something you guys want to see, let me know in the comments below. And then make sure that you're subscribing to our YouTube channel, as well as all of us on all of our social media outlets. And then you can also find this podcast on all your major podcast platforms, like Apple, Spotify, Amazon, all of that good stuff. So make sure you're downloading it there, subscribing, and jumping on social and engaging with us. Let us know what you want to see. Let us know what you want to hear about, so that we can bring it to you, continue that communication, so that if the time comes, you are prepared to defend.